நீங்க வச்சுக்கலாம். Yeah, please. Right. Now, just I would like to give some advice for you here. You are sitting here, but listening is one aspect. So many people are using these tobacco products. Hence, you are using here in the classroom and you are throwing the packets here. You are all grown up children. Why you are resorting to these sort of intoxications? ஏன் கிளாஸுக்கு வரும்போது அதெல்லாம் யூஸ் பண்ணலாமா? You assume one thing. You got married. You got married and you are doing a lot of for your family. If your child do this, can you accept this? You analyze yourselves. You are coming கோயில் போகும்போது tobacco bottle போலாமா? So many people are using hands here. Why you have been addicted to this sort of intoxications? Yeah, you are all grown up. You analyze yourself. Have some conscious. உங்க வீட்ல உங்க அப்பா அம்மா எல்லாம் ரொம்ப கஷ்டப்பட்டு உங்களுக்கு காசு கொடுத்தா you are coming into the class, you are not listening. Okay, it's up to you whether you listen or not. In the class you are using tobacco products. You analyze. எந்த விதமா இது வந்து appreciable? Kindly listen. ஆமாவா இல்லையா? This is for not for those who are not using. It is only for whoever is using. Addiction and enna, it's not tobacco or drinking or smoking. Anything is addiction. I have seen so many people walking cell phone, eating cell phone, seeing cell phone, seeing cell phone. They don't know even surroundings also. Right. Lastly, dying cell phone. Dying cell phone. Whenever you die, you make a will. What? Please, yeah, samadhila and the cell phone kuda vechidunga solano. You know why it carries so much of secrets will be there in your mobile phone. Amava illaya? Yes, sir. Yes. I used only small cell phone. You know why? Na younger no track panna kodadanga yaro. Illa pone wife kepa video call podannuva. Video call ponnom. Idella issues agum. It carries so many secrets with you. Right. You are all grown up children. Please, whenever come to the class, learn something. ஏதாவது கத்துக்கோங்க. Right? You see, I am telling something. You listen. You listen. I will tell anything. You listen. You listen. I will tell nothing. You listen. You listen. I am not telling something. I am not telling anything. I am not telling nothing. I am telling exact thing. Right. I am telling like at least it's appreciable. Ella class value some complaints we are not listening, but in my class it's good. You know why? I am connecting to you. Amava Ilya. I am connecting to you and you are connected to me. Right. Huh? You are addicted to me. Anything right? More addiction is not good. Right. No. Whoever comes to my class, whoever is following me, so many attitudinal changes or their attitude. Your attitude is important. If whenever a situation comes, how you are dealing with this situation is very important. My students, first they have some attitude. Slowly they will come to my class, listen to my class. They change their attitudes. It's good. Why? I am connecting to you. Right. So please listen, don't use hands. Chocolates எல்லாம் சாப்பிட்டு அங்க போடாதங்கோ. ஒருவேளை சாப்பிடணும்னா எனக்கும் ஒன்று கொடுத்துட்டு நீங்க சாப்பிடுங்க. Please give me one also. Then அப்ப நான் கம்ப்ளைண்ட் பண்ண மாட்டேன். Right. கண்ணன் எங்க? Right. Yeah. Yes, yeah, please. Listen to the class. So arbitrators, right? Arbitrators include arbitral tribunal also. arbitrator includes arbitral tribunal also. Right. Now we have seen the powers of the tribunal. Whenever a preliminary issue is raised, without resolving that preliminary issue, you cannot go into merits of the case. Yenda court analo enganalo kuda, if you are raising a preliminary objection without passing an order on the preliminary objection, you cannot go into merits of the case. For example, court ponango, you are raising an one objection that the court don't have jurisdiction. Right. Now what the court has to do? It has to pass an order on the jurisdiction. Assume that court don't have jurisdiction and it is telling that I have jurisdiction and pass an order, then you can question that jurisdiction in appeal. Without raising the preliminary objection, ఒక objection raise చేసినప్పుడు preliminary దాన్ని resolve చేయకుండా you cannot go into the merits of the case. This is very very important. Right, even arbitrator or arbitral tribunal is having certain powers to what is called resolve the preliminary objections. Right. Now next one is determine applicable law on seat of arbitration. Right. If parties fail to determine the applicable law, normally parties enna pannalam, they can select the appropriate law also. Which law will apply to this arbitration? They can select. If the parties fail to select the law, then arbitral tribunal shall apply the rule of law. Normally, whenever you are entering into an arbitration agreement, you are telling the seat of arbitration applicable law எல்லாமே agreementல சொல்லுவோம். ஒருவேளை agreementல சொல்லல எந்த law apply ஆகும் சொல்லலன்னா, then arbitral tribunal itself may apply the law which depends upon the circumstances of the case. Tribunal ఏం చేస్తుంది అంటే నువ్వు నాకు చెప్పలేదు కాబట్టి నువ్వు చెప్పితే I will apply this law. If you don't tell, I will select the law which fits into the case. So, the determine applicable law and seat of arbitration. Fourth one is determine language of the arbitration. Language also the arbitral tribunal can select. Why? You are going to the tribunal, giving evidences also, appreciation of evidence will be there. So the arbitral tribunal can also determine the language. So here Arbitration Conciliation Act, if the parties fail to designate any language, then tribunal shall determine the language or languages to be used in the arbitral proceedings. The language determined shall apply to any written statement by the party, claim of defense, any hearing also, in which language the hearing should go, and on any arbitral award, passing of the award, any decision or other communication by the arbitral tribunal. Language also you have to select. Right? Why? Normally trials will be there, some sort of proceedings will take place before the arbitrator. You are filing so many objection statements, statement of claim, statement of defense. எந்த லாங்குவேஜ்ல நீங்க ஃபைல் பண்ணணும், அவார்டு எந்த லாங்குவேஜ்ல வரும், டெசிஷன் எப்படி இருக்கணும், கம்யூனிகேஷன். Again, decision is different. Decision is different. It is not the final award. Preliminary objections paina decisions vastayi. Preliminary objections paina decisions will be there. Right? So any communication by the arbiter. Next one, direct the disclosure of specific documents and appoint experts. So normally arbitrator is not a what is called man of all knowledge. Sometimes arbitrator even feels difficult in resolving the dispute. Arbitrator வந்து எல்லாமே தெரியும் arbitrator கண்ணா. Sometimes you know in evidence expert opinion is there. evidence, expert opinion is there. Normally, yes, whenever a court finds it difficult to resolve the dispute, it will call for the expert opinion. Now, once the expert comes to the court and gives the opinion, it is not mandatory on the part of the courts to accept the expert opinion. You understand? ఒకసారి ఎక్స్పర్ట్ కోర్టుకు వచ్చి ఎవిడెన్స్ ఇస్తే దాన్ని యాక్సెప్ట్ చేయాల్సిన పని అయితే కోర్టుకి లేదు. ఇస్తే క్రాస్ వెరిఫై దట్ ఎక్స్పర్ట్ ఎవిడెన్స్ విత్ అనదర్ ఎక్స్పర్ట్ ఆల్సో. ఒకసారి ஒரு வாட்டி எக்ஸ்போர்ட் எவிடன்ஸ் கோர்ட்ல கொடுத்தா அத கம்பல்சரி ஆக்செப்ட் பண்ணணும்னு அவசியம் கிடையாது. It can cross verify. Once if the expert opinion has been accepted by the court, that becomes opinion of the court. ஒரு வாட்டி accept பண்ணா the role of the expert comes to an end, that becomes the opinion of the court. Here also the arbitral tribunal has powers to compel disclosure of all statements. It can ask the parties to produce the statements. It has documents or, excuse me sir, there is some etiquette attached to something. No. It's I am feeling somewhat, you are all grown up. You are all grown up. That's what I am telling. Anything addiction is harmful to you. You can live without oxygen. You can live without your parents. You can live without your wife. You can live without your children. But you can't live without cell phone. No, that is why. No, I am not pinpointing you. I am not pinpointing you, or I am not doing something. No, just I am telling you why. நாலு சின்னப்ப செல்போன் எல்லாம் கிடையாது. அதனாலதான் ஏதோ நாலு வார்த்தை கட்டுங்க மைண்ட்ல இருக்கு. உங்களுக்கெல்லாம் எல்லாம் செல்போன். That's why your brain is not working. This is the real thing. You see, you will become very old at the age of 60. Everybody will get Alzheimer's. You are going to see. Yes, sir. Please take your seats. Good morning to all of you. I'm very happy that very good number of students are attending the board observation classes and these special classes in the final year. This is a must, and all the students are expected to participate in this final year special classes and board observation classes. So those who are going to the board, please don't take your four-wheeler or two-wheeler to the board premises, because very strictly warned by the honorable district judge. Right? That is one thing. Second one is, many of the students, especially backbenchers, are using hands and throwing it off there itself. That creates a very bad atmosphere. Right? That is the reason why I just wanted to give you not to use hands. At least after going out of the campus, you can use hands and throw your doubts wherever you want, but not in the college premises, especially in this hall. Because up to 4 o'clock, you will be here. Next day morning, 9:30, you will be here. So in between, there will not be any workers to clean. So please don't repeat it. Many of the students are using backside, especially hands, and you are just throwing in front of your seat itself. Right? Please don't follow that. Avoid this. See, always in your life, try to follow the good habits. Generally, the drivers and workers may tempted to use hands or other things.
But I don't know being law people, we are law people, but we are also traveling with the drivers and workers using these type of things. Please don't repeat it. Kindly maintain high silence when you are coming to the college. The moment when you enter into this building, especially, maintain high silence. Even when you are passing through steps, kindly maintain high silence so that that will help you a lot. Try to avoid unnecessary talk that helps your health. I'm telling you very frankly, don't talk unnecessary things. You will get excited and you will lose your mental power also. Preserve your mental power for certain important things to come up in your life. Right? So please with these words, I would like to once again call all the students to attend all the classes very regularly so that all of you will get to it. Right? Those who are coming classes very regularly and those who are maintaining high discipline will be awarded good marks also. Right? So kindly follow these instructions and prove that you are the best students of Dr. Ambedkar Global Institute. Okay? Thank you. Thank you, Anna.
Yeah, please. Right? Right. Now you are a dignified lawyers. Now you assess yourself whether to resort to these sort of practices or not. Anything which affects you, that is an addiction, please leave this sort of things. Now the direct indirect சொன்ன சார் direct சொன்னா workers drivers போடுவோம். So you want to be in that way, do it. Oh no, you can do it. It's your fundamental right. Right under Article 21. Subject to reasonable restrictions, not in the class. Go outside and do it. Right? Yeah, please. So, right now we have seen disclosure of specific documents and appointing the experts. So they can compel you to disclose certain documents, other information supplied or applications made to the arbitral tribunal shall be communicated to the other party, export reports or communication. Then the arbitral tribunal may rely in making its decision shall be communicated to the parties. Now, like civil courts, arbitrator is also empowered to give certain interim relief. Interim relief he can give. So provide interim measures. Its previous act, there is no such interim measures is there. Under the new act, we are providing certain interim measures. If you know the what is called course procedure, main order will be there, interim orders will be there. Right? Normally courts ఏం చేస్తాయంటే for example you go and file a writ petition in the court. Right? You are asking for something. Municipality is there. Municipality wants to evict you. Municipality ఉంది మీ ఇళ్ళని కొట్టేయాలని చెప్పి నోటీస్ ఇచ్చింది మున్సిపాలిటీలకు உங்க வீடு డెమాలిష్ பண்ணணும்னு சொல்லி நோட்டீஸ் கொடுப்பாங்க. You are going and filing the petition in the High Court. Now High Court says, I cannot go into the merits of the case now. I will pass an interim order till High Court passes the final order. Municipality cannot touch your house. Municipality cannot touch your house. I can give you some interim protection. Once after hearing the merits of the case, then I will decide. I will decide means I don't decide that your house should be demolished. I will give the final order based on the decision to be taken by the municipality. వాళ్ళు తీసుకుంటారు బట్ ఇప్పుడేం చేస్తాను I am going to give you interim protection. That means it will go on till final order will be passed. Likewise, award includes interim award also. So arbitrator is having the ability and capacity cost interim measures. One of the important changes brought into the arbitration legal framework in India by the Arbitration Conciliation Act is empowering the arbitral tribunal to pass interim measures under section 17. Right, this is one of the important changes in the new act. Next one is pass awards on merit or terminate arbitral proceedings in case of default by a party. Right. This is another power of the arbitral tribunal. So, according to section 25 of Arbitration Conciliation Act, unless otherwise agreed by the parties, you know, in a suit, plaintiff absent, suit is dismissed. Defendant is absent, ex parte order will be paused. Likewise, once you accepted for the arbitration, if the claimant fails to communicate his statement of claim, if the claimant fails to communicate the statement of claim in accordance with the so and so, the arbitral tribunal has power to terminate the proceedings. Claimant రాలేదు అంటే ఆర్బిట్రేషన్ ఏమవుతుంది, టెర్మినేట్ అయిపోతుంది. சூட்ல கூட plaintiff கேஸ் ஃபைல் பண்ணి plaintiff வரலன்னா సూట్ வந்து డిస్మిస్ అవుతుంది. plaintiff వచ్చి defendant రాకపోతే then court will pass an ex parte order. Likewise, arbitral tribunal also, if the claimant does not turn up, subsequently entire proceedings will be terminated. Right. Also, if a party fails to appear at the oral hearing or to produce documentary evidence, arbitral tribunal may continue the proceedings and make the arbitral award on the evidence before it. If you are not able to produce the documentary evidence so and so, based on the evidence available, the arbitral tribunal will pass an award. Next power is order for cost. Again, this is subject to the agreement. Subject to the agreement. Subject to the agreement in contrary, the arbitral power has power, arbitral tribunal has powers to order cost. File பண்ணும்போது you are asking for cost. Likewise, whenever you are going before the arbitral tribunal, cost కూడా అడుగుతారు. ఏమని, వాని వల్ల నేను కోర్టుకు వచ్చినా, వాని వల్ల నేను డబ్బులు ఇచ్చినాను కోర్టులో, లాయర్కి ఇచ్చిన ఫీజు, కోర్టు ఫీజు కట్టినాను, ఆ డబ్బులు ఎవరు ఇవ్వాలి, டிஃபெண்டன்ட் இவ்வாறு. யார் காசு கொடுக்கணும், அவனால நான் கோர்ட்டுக்கு வந்தேன், அதனால அவன் கிட்ட எனக்கு காசு வாங்கி கொடுன்னு சொல்லி you are asking the cost also. Right. புரியல. plaintiff மாத்தையா plaintiff மாத்திரம் தானே. I think நாலஞ்சு plaintiff இருந்தா என்னன்னு கேக்குறியா? plaintiff ரெண்டு மூணு பேர் இருந்தா என்னன்னு கேக்குறா? எந்த plaintiff வரலையோ அவன் வரைக்கும் சூட் டிஸ்மிஸ் ஆகும். ரிமைனிங் plaintiff will carry on. எல்லாம் டிஸ்மிஸ் பண்ண மாட்டான். அது மாதிரி கேட்கணும். ரெண்டு மூணு பேர் plaintiff and so many persons are there. If any one plaintiff is there, அவன் மேல சூட் டிஸ்மிஸ் ஆகும். ரிமைனிங் பர்சன் ரிசூட் மீன்ஸ் அவன் எந்த ரிலீஃப் கேட்டானோ அந்த ரிலீஃப் வராது. அந்த வரைக்கும் தான் சூட் வெளில எடுப்பான். மிச்ச plaintiffs எல்லாம் கண்டினியூ ஆவா, the suit will go. புரியுதா? क्वेश्चन கேட்க கரெக்ட்டா தெரியல. ரைட். నౌ అంతే కదా, ఏ plaintiff రాలేదో అంత వరకు తీస్తారు. డిఫెండెంట్ ఎంత వరకు రాలేదో వాడు ఎక్స్పార్టీ చేస్తారు. డిఫెండెంట్ నాలుగు పేరు இருந்தா మొత్తం వరల అవమానం of ex parte order, they are going to pass. Right. If you remember interpreter suits. Interpreter suits ನಡೆಯಬೇಕಾ? Interpreter suits ಕೇಳಿಯಾ? ಅವನು ಕೇಳಿದ ನಾವು ಕ್ಲಾಸ್ಗೆ ಬರ್ತಾನೆ. Right. Right. Now cost. These are the what is called terms in the cost. Fee and expenses of the arbitrators and witnesses. Yes, the arbitral tribunal has power to award the cost. Cost ఏమేం ఉంటుంది అంటే fees and expenses of the arbitrators and witnesses. Legal fees and expenses also covered under the cost. Any administration fees of the institution supervising the arbitration. These are also covered under the cost. Any other expenses incurred in connection with the arbitral proceedings and the arbitral award. Right. These are the powers of the arbitral tribunal. Now we are going into duties of the arbitral tribunal. Powers to some power always carries duties. Right. Now arbitral tribunal has also certain duties. First one is duties imposed by the parties. That means by the consent agreement only you are going. Parties ఎలా చెప్తే అలా ఏం చేయాలి? Dispute ని resolve చేయాలి. Subject to provisions of law. Understand? Whatever the parties tell, you have to resolve the disputes subject to provision of law, provision of substantive law, provision of procedural laws, provision of arbitration conciliation act and constitution. ఎలా అంటే అలా చెప్పకూడదు. ఈ చెప్పింది వింటాను, దీని లోపలే within this I am going to pass an award. Specific duties may be imposed upon an arbitral by the parties. You can impose a specific duties also. This may be done before the arbitrators are appointed, or after the arbitrators are appointed during the course of arbitration, or both. Right. Now, if it is done before the appointment of arbitrators, each arbitrator should check the agreement before accepting the appointment. So, whenever an arbitrator is going to resolve the dispute, he has to see the agreement within which he has to see the scope of the power within which he has to act. In case it imposes unreasonable duties or duties that are incapable of fulfillment. Two types of duties are there. One is imposed by the parties, another is imposed by law. ಒಂದು parties impose பண்ணுவா, ಇನ್ನೊಂದು ಚಟ್ಟ ಪ್ರಕಾರ he has to go. Second duties are other duties are imposed by law. Even he has to follow both parties as well as law. For instance, law may require an arbitral tribunal to decide all procedural and evidential matters, to treat the parties fairly and impartially. For the panel of arbitrators shall be in majority and make a reasoned award and in a particular form. If you again go to the principles of natural justice, hearing, notice, hearing, third one is reasoned order should be there. Normally principles of natural justice లో మూడు ingredients ఉంటాయి. One is notice, second one is hearing, third one is reasoned order should be passed. Arbitrator shall also pass a reasoned order. Right. Now, sometimes arbitral award can be challenged on the basis of bias. Bias. Why? You know why? For arbitral proceedings, principles of natural justice will apply. Bias ante bias can be challenged at any point of time. Right. సో ఆర్బిట్రల్ ట్రిబ్యునల్ కి ఏం అప్లై అవుతుంది అంటే ప్రిన్సిపల్స్ ఆఫ్ న్యాచురల్ జస్టిస్ అప్లై అవుతుంది కాబట్టి బయాస్ అనేది యూ క్యాన్ ఛాలెంజ్ చేయొచ్చు. డిఫరెంట్ టైప్స్ ఆఫ్ బయాస్ యు నో, పర్సనల్ బయాస్, పెక్యునరీ బయాస్, బయాస్ ఓవర్ ది సబ్జెక్ట్ మ్యాటర్. నౌ according to Arbitration Conciliation Act, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his independence and impartiality. If you are getting a doubt that he is connected with the other party, then you can challenge the award on likelihood of bias. ఒక జడ్జి ఉన్నాడు అనుకోండి, ఫర్ ఎగ్జాంపుల్ వన్ జడ్జ్ ఇస్ దేర్, he is having shares in Reliance company or his son is having shares in Reliance company. If Reliance company case before that judge, he has to withdraw. లేకపోతే ఏమవుతుంది, there is no doubt judge is impartial, but there is apprehension of likelihood of bias will be there. Yes, that's what bias, likelihood of bias. There is one proverb is there, justice should be done, seen to be done also it is there. Yes. 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 Why you are taking the oath? To break the oath. Why you are taking the oath? Why you are giving promise? To break the promise. Promise ఏం అన్నాం? ఎందుకు చేస్తాం ప్రామిస్? బ్రేక్ చేయడం. అర్థమైందా? మీరు ప్రాక్టికల్ ఆలోచించాల్సిందా? ఎంతో మందికి ఎన్నో ప్రామిస్ చేయడం ఫుల్ఫిల్ చేయగలవా? You have given so many promises to so many people are fulfilled. నువ్వే చేయలేదు, జడ్జే చేస్తాడు. అయినో నువ్వు ఎవరికి ప్రామిస్ అయినావో, ఏం ప్రామిస్ అయినా అది తెలుసు. யாராவது ప్రామిస్ பண்ண, என்ன ప్రామిస్ பண்ண எனக்கு எல்லாம் தெரியும். Right? Yeah, you know why? Even I promised so many things, I didn't follow. నేను நிறைய ప్రామిస్ பண்ணேன். எப்போ என் டிகிரி எடுக்கிறப்போ எத்தனையோ ப்ராமிஸ் பண்ணேன். அதெல்லாம் உங்களுக்கு பண்ணனா ஒன்றும் பண்ணல. Right? Again, coming to law, if you again there are sometimes remedies out there. No, if you think that order has been passed on bias, you can challenge the same. Okay. Yeah, I know. It is there. No. No. That's what in the first class discretion of the courts. That's it. Condonation of whether one case comes 1 day late, dismiss. One case comes 20 years, admit. Right? Right. So promise is to break the rules. Right. So when bias can be challenged, right? If circumstances exist so as to give rise to doubts, then you can challenge the award. Then you know this is the case. Landmark judgment in bias, administrative law. Gullamapalli Nageshwara versus AP State Road Transport Corporation. You have read this case law in Gurtula case administrative law. Yes, this is the landmark case on bias. The Supreme Court stated that principle of natural justice, that authority empowered to decide a dispute must be one without bias towards one idea or the other in the dispute. There can hardly be any doubt about these fundamental principles of natural justice. Right? These are the possible grounds for challenging the bias. Let's see. The relationship of the arbitrator to one of the parties was unknown to other party. This is first ground. The arbitrator has performed as a lawyer, legal officer, or legal consent for any party in the past. He has represented the person in so many cases. The arbitrator has been adjudicated in any matter before him in the capacity of a judge. These are the grounds for challenging the bias in the award. Fraudulent collusion. Arbitrator was indebted to one of the parties. Right. So, if bias has been, there is a likelihood of bias, you can replace the arbitrator. Right. Grounds for replacement of arbitrator. Arbitration Conciliation Act provides certain other grounds apart from the ground of independence and impartiality for replacement. First one is becomes de jure or de facto unable to perform its function. That means automatically by virtue of law, his office becomes vacant. అర్థమైందా? By operation of law, he has been appointed. Appointed by whom? Parties. Parties. Right. ఇప్పుడు ఏమైంది? Once he has been appointed, he has been subjected to some insane. He has become insane. Automatically ఏమవుతుంది అంటే de jure or de facto his office becomes vacant. He is unable to perform the function. After the appointment of the arbitrator, he has become insane. What am mentally he has become ill. Automatically, his appointment comes to an end by virtue of law, operation of law. That is known as de jure or de facto, unable to perform his functions. Right. Second one, fails to act without undue delay. He withdraw from his office for any other reason, and by agreement parties decide to terminate his mandate even before the start of the arbitrator. The appointing authority is the parties, so appointing authority can terminate the agreement. So these are the grounds on which the functions of the arbitrator comes to an end, right? The main see.
అట్లా తీసేసింది ఏం కాదు.
ఎత్తులు బయట
சும்மா லைவ் மட்டும் ஆ, சில பேர் வேணும்ன்றாங்க மேம், சில பேர் வேணான்றாங்க. எதுவும் இல்லை. என்ன சார் எந்த மேம்? ஃபர்ஸ்ட்ல இருந்து கேள்வி கொடுத்து மேம் ஆஃபீஸ் மேம் வைரஸ்
Please sit down. Morning, everyone. தூங்குறீங்களா எல்லாரும்? பேக்ல இருந்து யாரும் தூங்கணும்னு சொல்ல மாட்டீங்களா? சரி. Please sit down, guys. At the back. இப்போ நீங்க உங்களோட கிளையண்ட் இருக்கு. நீங்க வெயிட் application கொடுக்க போறீங்க. He has submitted some kind of claim. And that some kind of claim, whether available or not available, obviously உங்களுக்கு எப்படி தெரியும்? This is clear. At the back, please settle down. Now your client is coming to you. The answer is like that. Other ஒரு client கிட்ட வராங்க. அவங்க வந்து yes, he's asking you for second date ஒரு போட்டுட்டோம். Now அந்த particular நீங்க mail application போடணும்னா you know the mail application is filed under the section 436 for mailable offences and 437 for non-mailable offences and anticipatory bail for 438. Okay. Now, இப்போ ஒரு party உங்களுக்கு வந்து mail application கொடுக்க சொன்னா how do you determine whether that particular offense is mailable or non-mailable offense? And based on offense தான் அந்த offense வந்து mailable non-mailable உங்களுக்கு எப்படி தெரியும்? அது cognizable தான் not cognizable உங்களுக்கு எப்படி தெரியும்? யார் சொன்னா? CRPC direct பார்த்துட்டீங்களா எல்லாரும்? அந்த CRPC பேக்ல ஒரு schedule இருக்கும். First schedule as well as second schedule. Now this first schedule deals with offences under IPC and second schedule deals with offences that are other than mentioned under IPC. Okay, special legislation. Now under this tabular column, there will be mentioned the section of offense under the IPC, what is that offense, what is the punishment of that offense, whether that offense is cognizable or uncognizable, whether that offense is bailable or non-bailable, and by which code can that offense be tried by. இங்க இருந்தா உங்களுக்கு புரியும் how and where you have to institute the complaint or bail application or whether that application or whether that offense is bailable or non-bailable. Clear? Now, if it is under special legislation, இது IPC ல இருக்கிறதுனால இந்த chapter column under mention under first schedule நமக்கு இங்க புரியும். Now suppose am I audible at the back? Can you hear at the back? punishable under another special legislation. Other thing every determine whether it is available or not available. It is mentioned in the second schedule. First schedule IPC related offences. Second schedule is special legislation and an offense. Other as you said, 3 years, 7 years, when a death imprisonment, life imprisonment, other offense. Available or not available, it is mentioned in the second schedule. Okay. Now, இப்போ ஒரு available offense வருது. நம்ம அந்த பேக்ல பார்த்து புரியுது ஐபிசில பண்ற available offenses செப்பரேட் ஆச்சுன்னா அது available offense. Now you have to file a bail application. You will under which section, under what provision you file a bail application? For bailable offense? 436 then our bail application for bailable offense filed. Now for bail or at what stage you can seek for bail? Arrest பண்ணி கூட்டிட்டு வந்திருக்காங்க. And from that moment, in the stage of the trial, நமக்கு bail application seek பண்ணலாம். At any stage, need not. At any stage, you can seek for bail application. Now, already we learned under 167 bail default, right? That is, the person is being imprisoned for 60 days, and if the person is imprisoned for 90 days, depending upon the nature of the offense, then you are entitled to be released on bail for the bail default. Other bail default is usually they won't release you automatically. You should be able to furnish the bail. What do you mean by furnish the bail? Before, suppose the court gives you impose some conditions upon you, you should be able to satisfy the conditions given by the court. For example, you shall not go beyond the jurisdiction of the court. You shall come to the concerned police station and put your signature every day. You shall not tamper with the evidence. You shall not cause any inducement or threat or promise to the persons who are acquainted with the case. So, these terms are called bail bonds. They impose some kind of conditions upon you, and the conditions are free out. That is release on bail, and without surety. When surety is not, surety or open surety or upon your own surety also they can release. So first thing is, if you want to seek bail and available offense, you should be able to, or you have capacity to furnish the bail. Clear? So clear so far. Now, if a person is deemed to be indigent person, what do you mean indigent person? Who doesn't even have 100,000 rupees for property value is deemed to be indigent person. Now the arrested person is an indigent person. Our value 50,000 rupees bond getting deposit definitely in to furnish the bail. Now the court would consider that person indigent person and அவனோட bail he can seek bail on his own and be released on bail only for bailable offences. Then second scenario is ஒருத்தர bailable offense arrest பண்ணி police custody ல 7 நாளா வச்சிருக்காங்க. He is in custody for 7 days in case of bailable offences. Now what the court would presume is that if a person is unable to furnish the bail even for a period of 7 days, then also that person would be considered as an indigent person and he can seek the bail. For 7 நாளா he is being police custody, judicial custody for bailable offense, and he is unable to furnish the basic requirements. Even on 10,000 rupees கூட அவரால் furnish பண்ண முடியல, custody-லே இருக்கான். And he is not willing to seek bail because of the conditions imposed. The court would consider him as an indigent person and he would be released on bail. Clear? Now suppose if the release ஆனதுக்கு அப்புறம் the conditions, any of the conditions mentioned under the bail is being violated. அவங்க இந்த jurisdiction வெளியே police station இன்ஃபார்ம் பண்ணாம போயிட்டாங்க. Or he has committed the same offense, he has repeated the same offense. Bail இருக்கும்போது that bail will be forfeited. அது forfeit பண்ணிட்டு he will be rearrested. He will be arrested and then court will show him give him a cause of show cause notice கொடுப்பாங்க. எதுக்கு அவரை திரும்ப arrest பண்ண கூடாது. And then this bail would be cancelled and put to jail. So when you file what is it? Bail under 436, these are all the conditions. 436 la nama bail கொடுக்கிறது வந்து for bailable offense. This is clear. Now, in what all scenarios and which all courts can give you not bailable offense? Not bailable offense க்கு bail சொல்றதுனா 437. Okay. Now, the magistrate court, the judicial magistrate of the first class, has the authority to give you the bail for non-bailable offense. Other court is the special powers. Now, under section 437, magistrate court also has the right to give you the bail. But there are conditions in circumstances under which a bailable, non-bailable offense, judicial magistrate of the first class, bail கொடுக்க முடியாது. First one, if the offense that is being committed is or offense which is punishable for imprisonment or for death, imprisonment for life, death imprisonment, or imprisonment for life or death imprisonment. These two circumstances, the judicial magistrate of the first class, non-bailable offense, bail grant பண்ண முடியாது. Now, the second circumstance is that if a person, the accused person, is committed an organized offense, ஒரு previous conviction இருக்கு, ஒரு organized offense ஒரு previous conviction இருக்கு, அது என்ன மாதிரி conviction? ஒரு minimum of 7 years imprisonment he has undergone, previous conviction. Then also the court will not grant bail on bailable offense. இல்லைன்னா ஒரு 3 to 7 years கொடுக்கிற ஒரு பனிஷ்மெண்ட் 2 or more occasions அவர் பண்ணியிருந்தாங்கனாலும் he will not be given bail under non-bailable offense. So under these two circumstances, the judicial magistrate of the first class cannot grant bail. First is for death imprisonment for life, or the person has previously he's been convicted for an offense which is punishable for imprisonment for life, or else for 2 or more occasions, for 3 to 7 years imprisonment for the matter offense he has committed previously 2 or more times, then also in that circumstance he will not be granted bail under 437. But in this order there are exceptions. Even though there are certain exceptions under which you will be entitled to get bail under these circumstances. First one, if the offender is a woman, if the person is sick, or if the person is infirm, or if the child is below the age of 16. This is the first circumstance. If the person is a woman, if the person is a infirm person, if the person is a sick person, or if the person is a minor, they are not minor, below the age of 16. In these circumstances also, bail கொடுப்பாங்க on bailable offense. Now, the second scenario is you have committed some kind of offense, that's clear now. But there is no sufficient ground to prove that he has committed non-bailable offense. Yeah, you have committed some offense, but whether it is dacoity or the theft or confusion, you have committed that offense. திருடி இருக்கீங்க, அது ராபரியா இல்ல dacoity இல்ல அது theft or confusion இருக்குன்னா, in that circumstance also you are entitled to get bail. Clear? Then and then also you got sufficient ground in there that you have committed the crime. First scenario, committed some crime, but you have confusion whether it is bailable or not bailable. Second scenario, there is no sufficient ground to prove that you have preliminary inquiry into that you have not committed any crime. Sufficient ground in there, you are entitled to get bail. Now, நம்ம நேரமா படிச்ச மாதிரி 60 days or 90 days you have undergone imprisonment, custody, then you are entitled to get bail in default. So these are the circumstances under section 437. You are entitled to get bail under for non-bailable offense. Generally, the judicial magistrate of the first class doesn't have the power to grant you bail for the offense that you have committed is death, or imprisonment for life, or imprisonment previous conviction of the organized offense you previously convicted பண்ணிருக்கீங்க, and it is punishable for imprisonment for life or imprisonment not exceeding 7 years, or 2 or more occasions, 3 to 7 years offense convicted, 2 or more occasions. In these circumstances, you are not entitled to get bail if not bailable offense. But you are a woman, you are sick, you are infirm, you are a child below the age of 16, then also you are entitled to get bail. Now there is no sufficient ground to prove that you have committed any offense. You are entitled to get bail. Now there is ground that you have committed some crime, but bailable or not bailable are given. In that circumstance also you are not entitled. You are entitled to get bail, and you can undergo custody for 60 days and 90 days respectively. In that circumstance also you are entitled to get bail under section 437. Clear? Now we will see a format in which you have to when or else the investigation of the is being continued. And say for example, for example, your office says you have committed a theft or likewise, whatever it is. Now, what is the punishment for theft? 3 years. If half of the punishment, 1.5 years, you have already been under jail custody and division custody, then also you are entitled to basically. Other after that you are released from it. And provided based on a monthly, so conditions are imposed on a monthly, that conditions you should be able to fulfill. That condition is mentioned under clause 3 of section 437. That is, he shall attend the court proposal, character he should be able to appear before the court. Then he shall not commit any offense, similar offense committed on another, and he shall directly or indirectly tamper with the other person. How do they get this tamper panno? Or he is like using threat or promise to the other person who is acquainted with the facts of the case. Our crime of the data, because now the use panno. If it does so, then the bail that is being given to him will be forfeited. Clear? Now, this is the format for bailable offense. So, not bailable offense under section 437. So, section 437 का नाम आप pension बोले. Generally, you will the cost side will discuss the you are filing under which code? Before which code? Then case number. It will actually be a criminal entity, and you have to mention the police station crime number. From police station mention under the because in order to ascertain the jurisdiction of the court, because Oro court is the Oro police station, crime was the Oro police station, the case was the Oro court, the specific court will be reported. So, in order to understand whether this crime has happened within the jurisdiction of that police station, which the court can take cognizance, then in that scenario, for that purpose, you have to mention the police station, crime number of that police station. Then the bail application, then parties, who's the petitioner? Petitioner or accused. If there is more than one accused number, which accused number it is. So you have to mention the petitioner's name or the accused name, then the states the police station. Sorry, the police officer. Then bail application filed under section 436 under CRPC. Now, then you have to mandatory state the prosecution case. Case of the prosecution and now. Prosecution charge sheet of prosecution case to be mentioned, right? That case has to be mentioned in brief. What is the allegation that has been mentioned against you? Whether it is theft, whether it is rape or whatever offense is alleged against you must be mentioned. Mention the date in which the offense has been committed, the place in which the offense has been committed, the by whom, against whom, if it is against the property, then it is property, then all the particulars of that charge sheet and the Ll.B. had to be mentioned in the small paragraph for the case of the prosecution. Then comes to your contentions. Other than I am innocent, why I am asking you to mention the names and times that you can see the defense of alibi. Right, I was in Western, other time I was elsewhere. The false allegation. I have nothing to do with the content. What is it? If there are all false allegations, so the content under the law is mandatory that you have to mention the name, time, place, and everything. Then you have to seek, like, bring before the court that I am innocent and I am ready and willing to perform whatever stringent conditions the court may impose. court imposed on the conditions I wish I abide by it. I really scolding before the court that I will do so. Otherwise, they can you have to find a state that the court shall give me the grant me the grant the bail application and shall be signed by the parties as accused and as well as the advocate of the accused. This is really set. So, quoting name of the court, then the criminal point number of dash of the police station is a Sasan police station that has to be mentioned, and the petitioner as well as the name of the accused. Accused when the could be if there is more than one accused. Together they can ask for an application or one at a time can seek for an application. It means individual or advocates engaged accordingly they will seek the application. Then against you, that is the respond would be the judgment is complainant would be the state. The police officer would be the complainant. Right. If it is by way of police report, the police officer would be the complainant. The bail application filed on behalf of the petitioner or accused under section 437. Then in another contention. The prosecution has demanded what all the things that happened. A prosecution case from the dates on which he was arrested till days when the prosecution case coming together and charged for example under which offense he is being charged, when he was arrested, all these things have to be mentioned in brief. And he should give the what is it? Promise that you shall not go with you shall not give guilt of justice. He is a permanent resident of the place, so there is no chance of going beyond the jurisdiction of the court. He will be able to get the process. If someone they will be able to get all those things have to be mentioned. And all that signed by the advocate as well as the accused. So this is how the bail application has to be done. Here under section 437. Here, right? Now we'll learn what is anticipatory bail. Anticipatory bail Anna. मुंजामे ओके मुंजामे எதுக்கு வாங்குறோம் யாரோ ஒருத்தர் எடுத்து சொல்லுங்க எடுத்து சொல்லுங்க யாருக்கு உன்ன வச்சிருக்காங்க என்ன மாதிரி கேஸ் if you have an apprehension உங்களுக்கு ஒரு பயம் இருக்கு that you have an apprehension that or a non-bailable offense எதிரா நம்மள arrest பண்ணுவாங்க you have an apprehension that you would be arrested for a non-bailable offense okay in that scenario you can see what is it anticipatory bail now this anticipatory bail is actually யாருக்கு கொடுக்கிற direction anticipatory bail arrest பண்ணுவாங்க இல்லையா கேஸ் ஒரு வருஷம் எப்படின்னா அப்படியா யாராச்சும் இருக்கா ஒரு நான் வேல் சரி சொல்லுங்க you can see anticipatory bail only for non-bailable offense. Now my question to you is whether a person would be arrested in the offense arrest பண்ணாம anticipatory bail? Okay. Now, when I have this anticipatory bail, can the police officer arrest me? Why? It is right. How can the police arrest you? Can the police arrest you? Actually, anticipatory bail means this is. It is for not bail office. The anticipatory bail issue for one. Okay. Now, actually, this bail letter it is a direction to the police officer who is taking the arrest. In the event of arrest, you shall be released on bail. Which means, இப்போ உங்களை arrest பண்ணுவாங்க. பண்ணும்போது நீங்க anticipate bail காமிச்சாங்கன்னா உங்களை arrest பண்ணுவாங்க. திரும்ப போக முடியும். That is what we mean by in the event of arrest, while you are being arrested, you shall be released on not may. You shall be released on bail. So that is what is called anticipatory bail. So anticipatory bail means you have an apprehension that or not bailable offense arrest பண்ண போறாங்க. Now you can see the help of the court by finding anticipatory bail under section 438 or please be silent. In the event of arrest, உங்களை arrest பண்ற டைம்ல you shall be released on bail. Clear? Clear so far. Now if you want to doubt we will take after the class. Okay. Now in the anticipatory bail application, what all things has to be mentioned? நம்ம bail application for not bailable offense எல்லாம் பார்த்தோம் that I shall not tamper with the evidence that all those things. பார்த்தோம் 437 clause 3 other conditions எல்லாம் சொல்லுது what all conditions can be imposed. Now in anticipatory bail, what all things you have to satisfy the court to get an anticipatory bail? There are 4 things. So they actually ஒரு condition கண்டிப்பா இருக்கணும். So if you are filing an anticipatory bail, these 4 conditions have to be mentioned. First one is you don't have any antecedents. Antecedents என்ன? prior இதுக்கு முன்னாடி ஒரு history கிடையாது. criminal history உங்களுக்கு கிடையாது. Second thing is you should mention about the nature and the gravity of the offense. Say for example, you are a minor child and you are rape பண்ணிட்டீங்க. It is of heinous crime. Then for such a thing, the court will not grant you anticipatory. If you have this apprehension, maybe for a simple theft, it's not that gravity would be taken by the court. Depending upon the nature and basically the discretion of the court would look into the nature and the gravity of the offense. Then antecedents of the case, antecedents of the accused, which is our accused petitioner. Antecedents of the petitioner, that is அவருக்கு ஏதாவது முன்னாடி ஒரு criminal history அந்த மாதிரி இருக்கா. Thirdly, whether he has any possibility of fleeing from justice. That is anticipated bail கிடைச்சா உடனே அவன் escape ஆகிக்கிற மாட்டேங்கிறா. Or if he அப்படி ஏதாவது இந்த court is generally the court will give an option and it will come to this. He fleeing from justice and second, fourthly, he has to satisfy the court that this allegations or the accusations is just to make it only to impute my character or reputation with my society. இப்போ என்ன what is it? You say that word. Kind of information like என்ன hurt பண்றதுக்காகவோ to put me into some kind of sufferance. He is எனக்கு எதிராக அவங்க கேஸ் ஃபைல் பண்ணுவாங்க apprehension இருக்கு. அந்த apprehensionனால தான் I am filing this anticipatory bail. So these 4 conditions has to be satisfied if you are seeking bail under anticipatory bail under section 438. That is, I don't have any previous antecedents. So I don't have any antecedents. The nature and the gravity of the offences, then I will not flee from justice, and this accusation is only for impute my reputation in society. If the court is satisfied, first the court would grant you an interim anticipatory bail. Interim anticipatory bail for the court order from that is for a period of 7 days. Now within that period, interim this anticipatory bail order ஆச்சுன்னா with order on a day the 7 days குள்ள public prosecutor will notice அனுப்புவாங்க. That's why so interim application has been granted. process your subsequent has succeeded in this defense, then this interim anticipatory date grant பண்ணது refuse பண்ணிடுவாங்க. If otherwise, that would be final. That interim anticipatory date would be final. In that also, section 437 was 3 the other conditions would be imposed. That he shall not be from justice, he shall not tamper with the evidence, all these conditions will be imposed to the judge order will impose பண்ணுவாங்க. So this is how you file an anticipatory bail. So anticipatory bail if you have an apprehension that an offense non-bailable offense எதிராக என்ன arrest பண்ணுவாங்க ஒரு apprehension இருந்ததுன்னா then I can approach a court of law and seek for anticipatory bail. That is in the event of arrest பண்ண டைம்ல he shall be released on bail. And fourth conditions has to be satisfied. Nature of the gravity of the offense, I don't have any antecedents, I do not plead from justice, it is only to impute my reputation to society. Then the court will grant an interim and interim pay will be granted. And it will stand for a period of 7 days. And in the period of 7 days, the public prosecutor will be given a notice, both the parties will be heard, then the final judgment will be final as a court order destination. Clear? That way, the police officer is about to arrest me. Now, if I have this anticipated bail, I have to be released. If I hand over, if I show the bail I ordered, I should be released. Then there. இப்போ எங்க வீட்ல வந்து அவங்க the buses come, the police officers come to my home and arrest me. Now I'm showing the bus I have the anticipated bail. Then you cannot arrest me. That's what I was saying. That's what I was saying. So this is the name of the court. Suppose already something has been there. That time the file number would be registered, right? For in that scenario, you can the file number of the case will be mentioned. Same way, you have to mention the prosecution case. What is apprehension of the feeling manner? You have this apprehension case will be filed initially. That should be mentioned. And you are seeking the case of the prosecution, all those things. Maybe over கூட இந்த ஆள வந்து அரெஸ்ட் பண்ணிருப்பாங்க. சோ அவங்க அரெஸ்ட் பண்ணனால என்னையும் அரெஸ்ட் பண்ணுவாங்கன்னு எனக்கு ஒரு பயம் இருக்கு. In that scenario, also you can be anticipated. This material will be circulated to you. And depending upon the each case, the contention would be different. So, other standard like the substance, depending upon that, you can elaborate your contentions. And if you have any documents to support the same, all those things have to be printed. Here, this bail application is for everyone. So, bail offense, non-bail offense, as well as anticipatory bail. So, everybody has a right to bail. This is a right. Actually, bail is the rule, jail is the exception. Jail, jail bail is the rule and jail is the exception. You are entitled as everyone to get the bail under CRPC. Here, now we will learn one more section. What I have shown you right now is as an advocate, நீங்க கோர்ட் முன்னாடி ப்ரொடியூஸ் பண்ற பெட்டிஷன் and format அந்த வேலையில தான் இருக்கு நீங்க அது கோர்ட் ஆர்டர்ல இருக்கு. அது ஜட்ஜ் would write the court order. Okay. அந்த ஆர்டர்ல பாண்ட் அதுக்கப்புறம் பாண்ட் ஃபைல் பண்றது. That is actually next. Another type of different type of pension that can be filed is maintenance. யாரு யாருக்கு எதிராக maintenance claim பண்ணலாம்? This is silent. யாருக்கு who can file maintenance petition against whom? Okay. அது யாரு ஃபைல் பண்ணலாம் செகண்ட். Against whom you can seek for maintenance under section 125. Against whom? This is the question here. Against whom you can seek maintenance under section 125. Simple ஒரே வார்த்தை தான். What the daughter can't maintain a father's name? I don't know. I'm asking against Hanan. Not my father to sue against me by petition against me to maintain it. Yes, my father's name. One code against a person you can seek maintenance under section 125 is a person who has the sufficient means and he is negligent or refusing to maintain the same. Get the sufficient means. Sufficient means what? Means what? Money. It is not money alone. Get the ஆரோக்கியம் இருந்தாலே போதும். If I can load எடுத்தாலும் நான் உள்ள பார்த்துக்கணும். Sufficient means varies from scenario to scenario. It doesn't mean he should be the sole breadwinner or he should be IT work a person, whoever it is, who has the sufficient means and he is refusing or is neglecting to provide the means, then that person will be the respondent. Irrespective of gender. Either mother da pathukkum, husband da pathukkum. Sometimes the wife can also maintain. There are case laws in which wife is entitled to maintain the husband if the husband is not. Yes. And the daughter can maintain the father. So maintenance is can be sought against a person who has the sufficient means and he is refusing to do so. Neglect பண்றாரு அவங்களால கொடுக்க முடியாதுன்னா then you can file petition under section 125. Okay. Now who cannot file? First, if it is against the husband, wife, children, parents, legitimate or illegitimate child. Then legitimate or illegitimate child and a person if in the petitioner and the petitioner is sick and infirm. How will they also entitled to be maintained? This is mentioned under section 125 of CRPC. That is wife who is unable to maintain. That is wife who is unable to maintain herself. For example, if I seek petition under section 125 and if the respondent is able to prove that I am an assistant professor of this college, then means I am able to maintain myself. Right. So for a woman who is unable to maintain herself. Now, the maintenance is there. How is that maintenance would be awarded? For maintenance petition of file பண்ணா court to look into what grounds and into the maintenance. It depends எப்பவுமே maintenance allow பண்ணும்போது the status of the respondent up to the status of the respondent is a doctor. அதே status maintain பண்றது கூட rights that the petitioner has. Now if the other person is a farmer, other status maintain பண்றது ஒரு rights. Now if that person is a pure work officer பண்ணாங்கன்னா அவங்கிட்ட போய் 10,000 rupees per hour salary 50,000 தான் இருக்கும். 10,000 கொடுக்க சொன்னா it is not reasonable. So depending upon the status of the respondent, the maintenance would be awarded. So wife unable to maintain herself, then a legitimate or illegitimate minor child or legitimate child who is not legitimate or illegitimate child who is not able to maintain herself, and also the father or mother and married daughter. Now the marriage changes for police CRPC law. So the particular case but minor changes, not total. It is actually section 125 is it is mentioned in section 144 in BNSS. BNSS. Now, இப்போ maintenance allow பண்றாங்க. Maintenance order could take time, right? The maintenance now actually I am a person unable to maintain myself. I have two children. I am seeking the before the court. The maintenance would be awarded maybe 2-3 years court order that the person would be objection கேட்கணும் hearing இருக்கும் postpone adjournments இருக்கும் so every immediate relief கேட்கறதுக்காக I am present likelihood I am asking the money. Now for that purpose you are entitled to file an interim maintenance application. Now interim maintenance application file பண்ணும்போது until the case is being disposed, the respondent is entitled to pay a sum of whatever the petitioner paid to perform. Maybe that they order panna or lesser amount can be ordered depending upon the cases. Now if an interim application is being filed before a court, now that court had to dispose that interim maintenance application within a period of 60 days. 60 days குள்ள அந்த transaction கேட்டு அதுக்கு order pass பண்ணணும். If the possibly within period of 60 days. Now 60 days interim maintenance application கொடுத்ததால எங்களுக்கு 5,000 credit percent 2,500 2,500 10,000 rupees maintenance per month interim maintenance the court has ordered. Now this person respondent is not paying the same. Is not paying the same or is making default ஒரு மாசம் கொடுத்தானா 5 மாசத்துக்கு அப்புறம் தராரு. So there is arrears in the payments. Now what is the remedy available to me? What is the remedy available to me? If that maintenance arrear இருக்கு period of 1 year தான் கட்டாம இருக்காங்க. That relaxation period has to be ஒரு மாசம் கட்டிட்டு next மாசமே போய் extra ஃபைல் பண்ணக்கூடாது. We file a CMP, okay. Now, if I file the CMP only after a period of 1 year, 1 year maintenance then I can file a petition and either his property can be attached or he can be arrested and imprisoned for a period of 1 month.
ശുഭം സാറിന്റെ അടുത്ത് പറയുക ചേച്ചി നമ്പർ ഉണ്ടോ ഇവിടെ ആരെങ്കിലും ഉണ്ടോ
Now, who all are not entitled to get maintenance even though these parties are mentioned? If the woman, if it is a wife who is stating in the petition, that's that woman is living in adulterous life. Adulterous life lead பண்ணிட்டு இருக்காங்கன்னா then she is not entitled to get maintenance. Or else, if the parties are living, the opposite party, the respondent is asking her, they are living separately. The opposite party is asking her to come and live with me by way of restitution of conjugal rights. Reason இல்லாம அந்த பொண்ணு ஹஸ்பண்ட் வேற இருக்காங்கன்னா then also she is not entitled to get maintenance. Thirdly, if that person, both the parties, the petitioners as well as the respondents, are mutual by way of mutual consent, ரெண்டு பேரும் பிரிஞ்சு வாழலாம் சொல்லி இருக்கிறாங்கன்னா that woman is not entitled to get it. So she is adulterous life or by mutual consent or she is living separately without any sufficient reason. Then also the court will not grant maintenance to that person. Now this maintenance petition would be எந்த jurisdiction file பண்ணணும் the place where they have resided, where the place he is residing, where they have last resided. These are the place of jurisdiction in which you can find the maintenance application. Now, in the maintenance application, if the respondent has appeared, then the order would be sent ex parte, and ex parte is for particularly after the 3 months time. Other than that, it will be taken against him, or the order will be passed against him. Now, what are the circumstances in which the order passed by the ruler? Change in allowances can be given. As you said, if the person has remarried, then you need not do the order outside control there. Then she, by way of any personal law, now the divorce I even divorce wife is entitled to right until she's remarried, she's entitled to it. No, if they have by way of settlement, and outside for settlement or another, she has received some wholesome amount, lump sum amount of money in Bhavana, then also she's not entitled to get. And thirdly, she's voluntarily surrendering. Then you are not entitled to get the same. This is section 125 to 128. Just goes and also இப்போ the same respondent க்கு ஒரு சிவில் சூட் ஃபைல் பண்ணிருக்காங்க சிவில் கேसेस வேற ஃபேமிலி கேसेस வேற கேसेस இல்ல the same family dispute என்ன நடந்திருக்கு and in that case also she has received some amount. This money can be set off with the money that has been paid with the civil suit. So this is section 125 under maintenance.
So same way.
Under section 125, the name of the court, criminals CMP number in MC का नाम maintenance application file पढ़ना है family court में ना judicial magistrate of first class jurisdiction. Family court also has jurisdiction. Then the petitioner's name. If the person is being representing the minors also that mentioned minors का है हम case file पढ़ना आपको maintenance को लेकर होना that minors has also been mentioned. Then all those things. Petitioner हुआ दे, respondent हुआ दे. If there are any areas and aripina, all those things have to be mentioned. And with this, we have come to an end of the criminal petitions. And there are some other petitions we have mentioned in the record books. Record book eppadi the first part would be the drafting part. First one, it would be divided into civil as well as criminal. The material would be circulated to you and correct according to the serial number you have to write. Then the second part is a conveyancing part, like sale deed, mortgage deed, gift deed, and another. A format will be given, you have to write this. Okay. Thank you.
Okay, second one. So last class we have already discussed about the drug trafficking and all entities. Today we are going to discuss about the general criminal justice system. What is criminal justice? There is no red pen for you. That's that. So mostly criminal justice system is or criminal. Criminal justice means the procedure where from starting from the initiation of the criminals, a criminal should to take the end or the giving of the judgment, disposal of that case. Whole system, whole procedure is known as a criminal justice system. That means your investigation, inquiry, trial, everything come under that system. And those are also a part of this criminal justice system by whom this system was worked out. That means if we talk about the investigation, mostly police and all those are responsible for this system. So police is also a part of this system. Next, inquiry can be done both by a police or a magistrate of court. So that is also a they are also a part of criminal justice system. Same as if we go to trial, might be it is your magistrate trial, summons trial, sessions trial, whatever it is. It is only for a domain of the court only, magistrates only. It cannot be done, trial cannot be done by the police. That is, all are, and among them, another part we are forgetting always, advocates. They advocates.
Might be it is from the prosecution side or from the defense side. They are also come under this system. So mostly for the criminal justice system, which include three procedures, that is investigation, inquiry, and trial, these five peoples are required for that system also. First one is policing, second one is prosecution, third one defense attorney, fourth one court, and the last one is correction homes. That means mostly your jail, prison, probation centers, and all these come under the last one. First one, policing system. If something happens to you or you done something wrong, so with whom you are first met with? Police. That means police are those persons mostly who are entrusted with maintaining the law and order systems, investigation, and all that part. That means they are here to protect us in single life. Now, as it is our part of discussion, let it for a later part. Okay, don't worry for right now. Next one is prosecution. If there is a criminal case was initiated in the court, who initiate the case? Prosecution initiate the case. Or prosecution. That means PP, FDP, they are initiate the case. Where they get this power? Where they get the power? That means it is their duty or it is their power. They can initiate the case from the side of the victim in the court. Section 24 of CRPC says that a PP or APP, public prosecutor, additional public prosecutor, or assistant public prosecutor can, or it is the duty of that person to initiate the case in front of the court. Section 24 gives the right and power of this. Not only section 24, section 25, 25A, which is section 24 says about the APP, section 25 says about the public prosecutors, section 25A deals about the directorate of the public prosecutors. So these are the persons, those who are, if you are a victim of any crime, you file a case, police investigated that thing. Once investigation done, that report, final form, whatever you can call it, it goes to the court. In court, who is going to help you? Advocates. If you are the victims, it is the, we call them prosecutors. So there, all of that things are happened from your pocket, right? Government's pocket. All that investigation, whatever is done by the police, governments. If it is in court also, it is done by the government only. But the point is, if you are not satisfied with what is done by the prosecution or PPF, whoever is there, question is, can you appoint a private advocate to for yourself? Yes, sir. Where it is given? Without procedure, how can they regulate?
You are the victim. There is a prosecution MPP or PPs are there to help you in the court, but you are not satisfied with the work of their. Those are also government. Whoever it is, PP, MPP, special PP, whatever in them organize. You are not satisfied with their advocacy. In that case, can you appoint your personal advocate? Where it is written? There is 486 sections are there. Done. 1 second done. 301. Check 301, sir. 301. So there in section 301 it gives the power to the public, to the victim who can appoint their own private pleaders, but they can only assist the PP or MPP. Clear? 301 says around. So among them there are different names for them. Advocate General, Government Advocate, Government Public Prosecutor, Assistant Public Prosecutor, like that. They are there. Next one is Defense Counsel. So there is a famous maxim in the criminal law or our legal system, there is that odi altum partem. That means, what does it mean? Hear the both sides. Or in other words, we are saying that you cannot give your judgment without hearing the other part. So when there is a public prosecutor or prosecution is there to help you in the court, what about the person who is there to defend himself? Can he defend himself by a advocate in the court? Yes, he can. That means defense can also appoint a counsel for himself in the court. Section 303. Section 303. Give the power to the defendant to appoint a advocate for himself. But the question comes, if the person is not capable to appoint a pleader, that means he has not that much means, money is not there with him to appoint a pleader. Because if you are also going to the court, in your initial days also you ask for 500 rupees for an advocate. Literally, if you are going right now, if you go to the court for any kind of affidavit, minimum 500 rupees they are charging. If it is a something very minimal case, theft or something, a advocate minimum they are going to charge you 5,000. That much amount is also not with you. In that case, are you debarred from getting the? So where it is the 304. Physical act is something different. Physical act mostly for both victim and accused. But physical force specifically give that where there is no means regarding the accused. In that case, court can give him a pleader, appoint a pleader on behalf of that accused to help him or to represent him before the court. Section 304 give the detail about it. Our case is investigated. As a victim, I get the advocate. As a accused, you also get the advocate. Now, second, next phase, where you are going to happen all these things in the court. That means the for the administration of that criminal justice. That means to give the proper judgment where we have to go to the court. That means it is the court's duty to give a proper judgment or proper what you call it justice to the person. Yes or no? If the victim is entitled for the justice, give it to him. If the accused is entitled, give it to him. That is the duty of the court to do it. Yes or no? Yes or no? What is? So if we go to in CRPC, you already discussed that things that kinds of courts and all. How many? What are the kinds of court in India? Basically, the CRPC, criminal system. We are not going to civil side. Only criminal system. I know that you all are the criminals. So basically, if we start from the hierarchy from the highest level to the lowest level, in the highest level, Supreme Court is there, where he has the jurisdiction of original jurisdiction, appellate jurisdiction, supervisory and advisory jurisdictions. In section 1, sorry, Article 161, you can find out all these things. And for the specifically for your read jurisdiction, you have to go to say Article 32 of the Indian Constitution. Next one, that means all our highest court of the land is the Supreme Court. Next one is our High Court. High Court is the highest court of a state where in under Article 226 there is the original and appellate jurisdiction is remain with them with the high courts. And in high court can also give any kind of punishment prescribed by law. That means there is no limitation for the either for the high court and supreme court also. No limitation is there. They can give any kind of punishment which is prescribed under law for time being. Next, if we come to our CRPC under which section? Section 6. Whatever, please check. There are class of hierarchy of courts are given there, and there are 6 only, na? 6. So there are hierarchy of courts under given under your section 6. That is your sessions code, additional sessions code, assistant sessions code, CJM, JMFC, JMSC codes are there. And under section 28 and 29 of CRPC, the powers or the jurisdictions of these codes are given. So, if you go to the sessions code or additional sessions code, what kind of punishment they can give or what is the power of that course? Under section 28, it is provided. They can give any punishment, but if it is a death sentence, there must be a confirmation from the high court.
section 361 or something it is given. Both sessions and additional sessions. Same as if you go to the sessions, assistant sessions code under section 28, they can give any punishment except life imprisonment or death sentence, that or imprisonment more than 10 years. In simple word, we can say that they can give punishment up to 10 years. Same thing happened with the CJ, Chief Judicial Magistrate, it is 7 years. JMFC, Judicial Magistrate First Class, that is 3 years or fine up to 10,000 rupees. JMSC, 1 year or fine up to 5,000 rupees. Clear? I have a doubt. I have a doubt. Let take an example of section 381 of IPC. What is section 381 says? That is theft by servant or clerk, where the punishment is 7 years. And if you go to the schedule of the CRPC, it is triable by the JMS. Okay. After the trial, investigation done, inquiry done, trial also done, and JMFC found out that no, he need a more punishment. Then he want to give that particular accused 5 year or 6 year of punishment. But the problem is he cannot give more than 3 years. In that case, can he give 5 year or 6 year? Transfer it to the higher authority. Where is the provision? Boss, whatever the procedure are, it is in the CRTC only. No, it is not about transfer of the case. It is not come under that 410, 411, no. No, it is not. Please go to the section 325. Section 325. Yes, sir. So, when a magistrate don't have that power to keep that particular sentence, in that case, he can transfer it according to the provision of section 325 to the higher courts. Here, now, last is remain here. Jail. It is also a different part of this. So, the list I have shown you that what is come under criminal justice system, that is policing, court, prosecution, defense counsel, and jail. So in between these three we have discussed court, prosecution, and defense counsel. We already discussed. Two things are remain. One is policing system, another one is jail system. First one come to the policing system. So if you go to the history, police, that particular word POLICE comes from the word policia or politia, whatever you can term it, which means administration of the state. That means a particular group who are there to administer them. Like here, I am here, I am giving you the lecture, but some other lectures are there to administer. Yes or no? We can term them as a policing system. And if it is a society, to maintain a discipline, to maintain a organized manner, that is policing system. So from if you go to the Sutherland's definition, they are primarily an agent of states whose function is to maintenance of law and order, especially enforcement of the regular criminal course. Okay. Time from immemorial. If you go to that Arthashastra, written by Kautilya or otherwise known as Chanakya, Arthashastra. So from that time, that means if, those who are history students, they can relate it. That time is known as Gupta dynasty. Before that, it is 100 Chandragupta, 700 BC or something before Christ. So from that time also, there is a group of people who are there to control the society or to maintain a law and order system in the society. In other way, there is a group who are there to enforce the law in the society, which is given order given by the king, emperor. At that time, they are known as the Dandadhikari. Danda Adhikari. Danda Adhikari. Danda, that means a stick Adhikari. And the chief of that person, known as Mahadanda Adhikari. And by the time when it comes Mughal period, they are most of the time they are known as Kotwal. Kotwals they are known, and once Britishers entered, they bring their own policing system. They have it is not about India only. In America, it is from 13th century the policing systems are there. Most of the time, at that moment, though they are the private agencies. Later on, state take over that agencies and make their own system. Same thing done by the Britishers when they entered here. So that is mostly the development of the policing system in our society. So there is always a group of people are there who are there to maintain the law and order system. Sometimes in the by the time we are knowing the police. So now kinds of policing system. What are the kinds? How many kinds of police are there? It is not there. Huh? State police. So mostly if we traffic department and all that things are there. So general police, traffic police, women police, home guard department, criminal investigation department, CID, CPI, railway police, military police, ITBP, Divakar. So all the kind of policies are there. But if we categorize that person, that department, mostly it is divided in two parts. One, they are those who are mostly responsible for the maintenance of law and order. Second one, those who are mostly responsible for the investigation department. In law and order maintenance, you can put everyone in that. General police, traffic police, your that CRPF, CIF, ITBP, all that things. And in investigation department, you can put CBI, CID, ED, whatever are there. ED, Enforcement Directorate. So probably they are mostly they are divided in two groups. And in between you can put any kind of policy. Now come to the what is the principle of policing system? Or in other words, we can ask why we need a police department. What is their duty? Fine. First thing for our safety. Yes. For first thing, that means when everyone knows that it is the duty of the state to protect us and our property. Yes or no? Yes. So how he is going to protect it? By the police. That means it is their primary duty to protect the society, or in other words, we can say that strengthening the security to the person and property. Next, after that, how that thing can be done? By maintaining a law and order system. Here, now on before that Sankranti, your Andhra Pradesh, Telugu people, you have Ugadi. Yes or no? April. Before Sankranti, that means Vishwa Sankranti, April 14. Before that, I think sometime before or in Sankranti time also, it is the Ugadi time. It is there. Yes or no? I think I am not. So at that moment, if there is person, how the police is controlling that person. Ugadi, your this Pongal, these are the very big festivals here. So to control the society, before that, if those who are connected with that kind of society, that means those kind of criminals, they are taken by the police. Yes or no? For example, before now at times it is not there. During mostly in Ram Navami time or Muharram time, they start the Julus when they are Julus or here Sobha Yatra we call it. So before that, police most of the time take some people, anti-social elements, those can create the problem during that either in Julus or Sobha Yatra. So that is in by that way they are maintaining law and order situation. If there is a crowd is clumping, maybe so to protect that thing, it is their duty. Yes, to eliminate the next one to maintain or to work towards the maintaining of the equality, liberty, and fraternity. But most of the time it is not happening. I mean, yes, as I give you the example. If you are how they are not doing it, practical example. If as a male person, if we are not wearing a helmet or if we don't have a driving license, immediately there is a challan. For girls, so it is they are imposing equality. Man is saying no. So take it in a lighter mode, okay? Don't take it seriously. So, but it is their duty. They have to behave equally to everyone. Yes. Same as upholding the human rights, effecting the prevention of the crime and disorder, like in your section 153 of CRPC. 141 says that if after the commission of the crime, police can arrest. Yes or no? 153 says that if there is a reasonable ground that some offences are going to happen, before the happening of that offence, to prevent it, they can arrest. Section 153 of CAT.
Then dealing with the criminals in action, contribute the weak people's faith by maintaining at all times a relationship with the public and investigate, detect, activate the process of the prosecution offenses. So these are main principles of policing. So till whatever we are discussed, so the role of the police is very important in our society. Yes or no? They are here to administration of the law, criminal justice, and they are here also to protect us from the offenders or any kind of crimes. But tell me, how many of you feel safe when there is a police? Anybody in your house? I think I'm not saying your friends. I'm saying that if you are feel safe or you don't have that anxiety and all that, it's why you saw a police. Are you? Unless and until any one of your family members is from the police. If my father is police, then only I feel safe. Okay, my father is police, so nothing is happening. But as a general person, layman, why they are not following that? Not about that rule and regulation. So they are not doing this thing. They are not following this principle that it is their duty to win the heart of the public. They are not doing that. That's why we are not feel safe while we saw it. Police is there. Just contact. That is a Gopal in Hindi. Chor chor chache. Now come to the role of the sorry, ma'am, any one of your family member I think police. Sorry for that. First one, role of the police. Prevention of the crime. Crime happened. Okay. There is system is there. But one of the main duty of the police to prevent prevent the crime from any source. They came to know that in films you saw that they get a tip from any source that there is a bombing or something is going to happen. So it becomes their duty to eliminate that thing or to prevent that thing from happening. As I told you, one section 153. Patrolling and surveillance. Then, same coming under that first point, there is going to happen a election is now when the election is May 13th. So before that, there is chances that political parties are going to distribute money or they are trying to influence the voters to cast their vote towards it. To stop that, there is flag march, there is say surveillance is there, patrolling is there done by the police. So it is not only about the casting of the vote or during the election. For any other time also, they have to do it because it is their duty to control the crime. Arrest of the offenders, those who commit crime, those who are going to commit crime, to arrest them.
In which cases police can arrest a person? Sorry, sir. What is? Yeah. 41. Can a police arrest a person who committed a crime of not cognizable nature? Yes, sir. Yes. Can arrest, but there must be an order from the court or warrant from the section 42, 42 or 40. So mostly arrest can be done on a cognizable cases which is given under section 41 of the CRPC. Then investigation, inquiry. That means in investigation and inquiry it comes that your filing of the FIR under section 154, 161 of taking, 161 statements, then taking if it is a victim need a 164 statement need to be recorded by the magistrate. It is to be done after in proper search, seizure and all that things are there. Section 47, section 100, section 90, 96, 95 to 100, all provision of search and seizures are there. So all that provisions are given there, and at last under section 172 they have to file the final form of charges they have to file. Clear? Same thing is given. That means under investigation, your interrogation of the offender or suspects are there, search seizures are there, maintenance of the inquest register is there. What is inquest? What is inquest? When you heard this word, murder. Yes, mostly in the case of murder. Unnatural death, murder. If you go to section 174 of CRPC, there you will find out that if there is a unnatural death is there, CRPC you can they can do it. Then next one is assistance of the public prosecutor. Public prosecutor is there to help the victim in the court. That means he cannot come to the field for the investigation. Whatever his power, it is in the court only. So, for the giving evidence in or producing evidence in the court, he need evidence, and evidence can be collected by the police only. So, if he is not helping the prosecution or public prosecutors, they cannot defend or give the relief to the victim. So it is their duty to help them. Last one, to enforce the judgment. Like recently you are come to that your CPC. What is order 21 says about? Order 21 CPC, civil procedure. Attached. Execution procedures. So court give the order, court give the judgment. He is not coming in the field to execute the order or his judgment. As a criminal, as a civil court, take as a civil court. He told that okay, this person 50% is goes to Mr. X, 50% goes to Mr. Y, or 33.33% goes to Mr. A, 33.33% goes to B, 33.33% goes to C. But which 33.33%? Court is not come to the field to measure it. Other persons are there. Same thing happened here. Criminal cases. I give you the as a code, as a criminal code, I give the judgment. This person going to receive 3 years of imprisonment, 1,000 rupees of fine. I give the judgment. But it is the police who is going to execute it. That means that one part of that policing system, jail, they are clear. Let you are the police. Let you are not the advocates, you are the police. What are the problems you face? Why you are executing your duty? Political pressure. But one of the most thing we as a police face, that is the non cooperation from the public. I said, what happened here? I don't see, sir. Now only I came here. But we are Indians. We can stand there to see how a JCB dig it down. But still, we said, no, I just come now. This is that is as a general public we are saying that. But ask a police. Ask a police. Ask a police. So first we are discussing that. No, no. We are discussing. First one is non-cooperation from the public. So how they are going to investigate that thing? Only based on that CCTV and all that, it is not cannot be possible unless and until general public is helping them. Second, lack of people's cooperation. Third one, lack of social responsibility. उसको मार पड़ी है मेरे को क्या? चोरी उसके घर में हुआ है मेरे को क्या? So that is our mentality. This things, his bike is stolen. What can I do for it? This is stolen. So that social responsibility, we have lack of that social responsibility as a general. Criminalization of the politics. Take any politician's name and go a deeper study of that politician. He is patronizing some criminals. That means political pressure is such. If we are as a police, we are going to arrest someone. Hey, he is my people. Let them go. Yes, sir. That is another problem. Even court look at the suspicion and the evidence put forth by the police. In your evidence act, it is clearly said, statement given before the police is not admissible in the court of law. So our law, legal system itself not believing one of its part. That's the major problem. And last one, higher police officers, they are treat the lower police officers as their servants. So these are some problems which are faced by the police department
while they are executing their duties. So in next class we are going to discuss about the criticism to the police officer and what is the mainly the failure, what is the cause of the failure of the police system in our society. That means we are going to discuss. After that, many other things are going to be there. For today, this much. Thank you and have a good day.
Violating all the time. So, in spite of they came and when they came to the home, after the police go away, he is again violating, encroaching the MLAs. Try to find fault with the booking and service. The MLA, so that we won't come and in such a case, what is the he brought me violating encroaching they are not violating.
The question here is whether the bird judge, you need to refresh, right? A judge. So we're discussing contempt by judges, magistrates, and other officers. So in continuation of yesterday's class, let us see whether the word judge includes judge of High Court and the Supreme Court. This was my question yesterday, and we have started the discussion. And so, have you gone through the section? Huh? 16. So, section 16. This is very important for your party and exam. In any part you may be asked. Okay. Whether the word judge in section 16 includes the judges of Supreme Court and High Courts. Are they liable for contempt of their own court or the other courts? No. Why? At most powers. Any other answer? Justifying no? In the start is okay, at least you may give a reading to section 16. Let me read for you. Section 16. Contempt by judge, magistrate, or other persons acting judicially. So, what section 16 says? Subject to the provisions of, listen, be attentive. Subject to the provisions of any law for the time being in force, a judge, magistrate, or other person acting judicially shall also be liable for contempt of his own court or any other court in the same manner as any other individual is liable, and the provisions of this act shall so far as may be applied accordingly. Understood the provision? Okay now. So, provision ನೀವು ಚದಿವಿ ಅದು ಅರ್ಥ చేసుకోవాలంటే with single meaning you cannot. You have to give couple of readings to provision. Okay. This is what section 16 says. Subject to the provision, subject to the law. Let us see. So, Patna High Court held that. This is where I stopped, I guess. Okay. The word judge in section 16 does not include the judges of Supreme Court and High Courts. The contempt proceedings are not maintainable against them. Why? What is the reason? The reason is this. Section 16 of the Act opens with this statement. What is that statement? Subject to the provisions of any law for the time being in force. Whether they are liable for contempt or not liable. Which means section 16 is subject to the existing law. Chuta. Existing law which was in force before the Act was enacted. So, before the Act came into force, the contempt proceedings were not maintainable against a judge of the court of record. Judge of court of record, the contempt proceedings came. So, they the court of record term. High Court and the Supreme Court. They are the courts of record. So, against them, contempt proceedings cannot be maintainable, cannot be charged. It ఇది ఒక సింపుల్. Then the High Court and Supreme Court are the courts of record. Because of that reason, and therefore the contempt proceedings are not maintainable against the judges of Supreme Court and High Courts. In state of Rajasthan versus Prakash Chand, relevant cases, you can quote as many cases as you want. The Supreme Court observed that Section 16 does not apply to the judges of Court of Record, but only to the subordinate courts. Only to the judges of subordinate courts, this contempt proceedings can be maintainable. In the court, only because of the position, the tag of Court of Record, they are not. కానీ ముందు ఎగ్జామ్ చేస్తారు కాబట్టి and subject to, it starts with subject to the law. And here I'd like to mention this one provision of this act. What is that act? Judicial Officers Protection Act. You can have a reference to it. Judicial Officers Protection Act. It says, Section 1 of the Act says, I have divided this particular section and highlighted with different colors for easy understanding. Okay? Yes. Section 1. No judge, magistrate, justice of the peace, collector, or other person acting judicially shall be liable to be sued in civil court for any act done or ordered to be done by him in the discharge of his official duty, whether or not within the limits of its jurisdiction, provided that he at the time in good faith. So, good faith అనేది ఒక difference. Provided. General rule ki ఒక exception. Provided that he at the time in good faith believed himself to have jurisdiction to do or order the act complained of, shall be liable to be sued in any civil court for the execution of any warrant or order which he would be bound to execute within the jurisdiction of the person issuing the same, provided that the acting in good faith. That's all. Those limited words gives us the meaning. Are they exempted or bound to? Exempted. When they acted in good faith, they cannot be liable for that. So, good faith ఉందా లేదా అని prove చేసుకోవాలి. Okay. So, this is all about the content of court act also. And now, we have come to the last part of your professional ethics subject. That is accountancy for lawyers. Accountancy for lawyers. And this is the last part of your subject. You have seen all the other. For example, let me 1 second. Yes. Starting from this, we have seen from day 1 to till. And we are at the end of this subject. Okay, accountancy for lawyers. And we have already seen all the above things and all lamps of advocacy, ethics, what professional ethics is, and whether advocate office is a firm, a business. Okay. in the lab and the experiment. Right? Note down the points here. Is it really required to know the basics of accountancy? Accountancy is one thing where every individual at one point of time uses. Even in our regular life, day to day, expenses are maintained. Yes or no? Few of us may not be having the practice of maintaining the accounts. But when we see our fathers, grandfathers, great grandfathers, they used to maintain a daily. Agree with this? How many of you have seen? Like, even me. So they maintain the daily expenses also.
The daily routine by platform.
He has seen, he is my relative, my cousin. Narayana is my cousin, okay? So he is expressing that he has seen the dairy which was maintained by my grandfather. Even I have seen. Thank you for recognizing. Okay? So, yes, every one of us present here has to maintain a book of accounts, has to maintain a record how much we are earning and what is the amount we are spending on. Whether we are on safe side or on the debt side. అప్పు చేయాల్సి వస్తుందా లేదు ఉన్న బ్యాలెన్స్ తోనే మనము ప్రొలాంగ్ చేసుకోవచ్చు. This is a very general thing, but it is an art. It is an art, and not everyone maintains this account. It is a systematic way of mentioning what are all the income we are receiving and what are the expenses that are coming and going. Income, expense. Okay, outgoing. So, as a professional, once you enter the profession, you start up an office, isn't it? Some of you may start an office, and some of you may join a firm, whoever it is. You need to bound, you are bound to maintain accounts, book of accounts. I will be explaining, though I am not an expert in accountancy and all, I have a basic knowledge on that. And so, based on that, we will have an interaction. Okay? Yes. So, what accountancy is? BCom students are here, and many chartered accountants are here, accountants are here, and so you can explain this in a very much better way. Let us see. Whenever doubt arise, we have an interaction. Expert opinion. Sitting in the first row. Okay. And so, what accountancy is? There are people who are very far from the science and maths. Okay. So, I belong to that category. Don't worry. I am here with you. So, you can note down because this is for an exam. One question definitely comes for exam from this chapter. Sure. So, it is an art, a science. Some argue it is a science and some argue it is an art. Art in the sense, art of maintaining the records. At one side, we mention income, and on the next opposite side, we mention the expenses. Okay. So if we don't know the basics, we note down one by one, income, expense. So what happens if it is not a systematic approach? If we do not follow an approach, what happens? It creates unnecessary confusion. So we maintain each and every point we spend and the amount we receive. If we don't follow a pattern confusion. We may not be in a position to finalize whether we are on safe side, profit side, or the loss. And so we need a technique, we need a process, a method. We can say it a method, a systematic method, which is acceptable. And so it is a method of organizing the accounts, recording the accounts systematically, and at the end we are going to summarize it in total and interpret the amount, whether profit or loss amount, whether income is over the expense or expense is over the income. What do we call if income is over the expense? Profit side. అబ్బా లాభంలోనే ఉన్నాం ఇంకొక నెల గడిపేయచ్చు. What if expense is over the income? We have to monitor. We have to introduce some methods to improve our financial position. మన financial stability చూసుకుంటూ ఉంటాం. Monthly the certain statements called profit and loss account statement, balance sheet. So prior to 2013, only these two were enough. But 2013 లో company amendment అయింది కదా. So with that you have to, along with those two statements like profit and loss, income statement and balance sheet, we have to submit cash flow statement. Cash flow statement. Okay. So we will be seeing in brief what all these things. In brief. So, as an advocate, you are bound to maintain accounts because you have to analyze your own financial situation at the end of a financial year. And coming to, is it mandatory? Yes, it is mandatory. It is mandatory. Advocate, the firm, advocate's firm, the law firm has to maintain. If an advocate is an individual person, not a mandatory thing, but it is his duty. It is his duty to maintain a record. He knows his own financial status. And he has to maintain the record because while discussing the duties, whenever your client demands, you must be in a position to show the account. What if you don't maintain an account? I spent for that this month. What is the proof? So each day, an advocate, a professional has to maintain this account to protect his own skin and to avoid all other legal complications that legal take. Next, the purpose of maintaining the accounts. The main purpose is to have a financial status, to know the financial status. Financial status includes what? Monthly with an annual income, annual income, and next, what is the amount that is due for tax? It's a tax cutter. What is the IT? IT standard number kada. Every year it changes. And professional tax. Even the payment of professional tax also depends on the income. Income enough for each and everything. And next, the amount due to the client and the amount due from the client. So monthly, when you maintain a proper record, you can claim the amount which is due from your client. Forget about about other things and all. IT, professional tax, అన్ని వదిలేయండి. క్లయింట్ నుంచి ఎంత రావాలి అనే పట్టు గుర్తుంటే సరే. Okay. And what is an annual income? What for? Only if he knows what is his annual income, he can make certain changes to his profession. Intare vachindi annual income. Okay. Next year I have to work hard to increase my annual income so that his status gets improved annually. And the other things and all, income tax. Every year an advocate has to pay an IT, be it a firm or an individual. Ikkada em exemption ledu. Even an individual advocate, though not connected with the firm, has to file an IT. And professional tax, you know very well, for every 6 months, professional tax has to be paid. And all these accounts can be properly managed with the help of these statements. Income statement, which is otherwise called profit and loss. Income statement, trading profit and loss account. Next, balance sheet, and next is statement of cash flow. And coming to the income statement, what for it is prepared? It contains the income and expenses, liabilities, assets and liabilities, income and expenses. What comes in, what goes out. Avana? I still remember my intermediate commerce schools. Real language. What comes in, what goes out. Okay. So it tracks the profitability of your income, your earnings over a period. For every period you can ascertain how much you are, what are all the expenses you are incurring. Is it necessary? Can be avoided. Expenses మనం ట్రాక్ చేయొచ్చు. అనవసరంగా స్పెండ్ చేస్తున్నామా లేదా, what is necessary, what is not. Next time we can. So based on this statement, we can be very prepared and cautious. Next, it shows the revenue, that is income and expenses. It neither tracks the cash receipts, cash receipts nor cash disbursements. So, what is this? What do we call this bottom line? Revenue plus gain, income minus expenses, expenses plus loss. What do we call this? I have mentioned like bottom line. What do you call this bottom line? Net. Then what is gross? What is net and what is gross? What is your net salary? What is your gross? What do you call a takeaway? That gross and net and takeaway is net gross. Net. And next comes the balance sheet. We will be seeing the rules also. rules laid down under the Advocates Act. That is Bar Council. Bar Council has stated it will not be attentive. This is important. Then what actually balance sheet contains? Balance sheet. It has to balance, right? Then only we call it as balance sheet. Anna, balance sheet situation comes where we are not able to balance it. Then what do you use? IP. No, not IP. Insolvency petition. General అదే జరుగుతుంది. బ్యాలెన్స్ చేయకపోతే ఐపీ వేస్తారు. సో ఎన్ని ఐపీలు ఉంటాయి? ఫిక్స్డ్ కదా ఐపీలు ఎక్కువ ఉంటాయి. So balance sheet is one. Then we will balance both the assets, income and expenses, assets and liabilities. While paying IT, you have to deduct, you are permitted to deduct certain expenses. Can you name few expenses? Not in balance sheet. Balance sheet లో మనం అవన్నీ చూపిస్తాం. ఏమేమైతే మనం లిస్ట్ చేస్తున్నామో జస్ట్ ఒక దీనికోసం డైలీ ఎక్స్పెన్సెస్ నా ఎగ్జామ్షన్స్ తీసుకుంటారు కదా. సో ఆ ఎగ్జామ్షన్స్ As a professional, I am talking to the advocate గా నువ్వు ఐటీ ఫైల్ చేసినప్పుడు ఏమి ఐటీ రిటర్న్స్ చేయాలి కదా. నువ్వు ఇండివిజువల్ అడ్వకేట్ అయినా చేయాల్సిందే. నో నాట్ రిలేటెడ్ టు ద ఫార్మ్. Traveling. Okay. No. Not yet. Traveling allowance ఎంత వస్తుంది? Oh, traveling from one port to another port, you mean to say? You're investing for your law library. You are investing for your law library because you have established an office. Can that be deducted? Capital advantage. What? See, this is not a loss, no, not a loss, right? Other company have an interaction. Still also then. For example, advocate while filing an IP, and చూపించుకోవాలి కదా. Okay, the books be purchased for his own library. Exception. రాసుకున్నారా? Previous slide. So what are all the books that an advocate has to maintain? Books of accounts. Let me know. Other than you, any other person can answer. What are all the books that an advocate has to maintain? Books of accounts. Books of accounts. All in the sense what? Income statement. Ah. Is it really useful for an advocate to maintain all this? Yes. Balance sheet. My question here is, do an advocate should possess knowledge of all these accounts, or he can just engage an accountant who will take care of all the bills and all that? An advocate did not know, he did not, but when he is not able to engage an accountant, instead of paying him salary, he himself can maintain all the accounts. When a fresher, when you are a fresher, you can maintain all the accounts of record, everything on your own, and the amount will be saved. Yes, this is from an advocate. Are you there? There is not. There is not. And you are coaches control. The naming coaches, just like the firm. When it is a firm, the naming coaches. But an advocate, an individual advocate, will not maintain all the records and all. And it goes just like a custom. And now, no, and now as we have this mobile transactions, e-mobile transactions, everything is recorded. No, with regard to the particular case. Yeah. You need not go to RTA and all. Because, see, filing RTA is the minimum, is very minimum. Very minimum. But the next month, that is what? You can have, instead of going to RTA and all, you can inform to the other, other authority, association. They ask them to produce. What do you can? You can, but what happens? The relation between you and your advocate is free. You may not get a very fair approach later on. So if you do not have a trust, then only the question of RTA comes. Right? So if you want to file an RTA, better to take your documents from him, approach another advocate, and you can file. That is what you can. Maybe in two classes, I will be finishing off this, and let us see the next topic. Yes. Previous. Next step, previous.